In these tough economic times, it is not unusual to see people fall behind with their debts. Given the current nature of our justice system, suing people just to collect is not only expensive but also impractical. What if I told you that there is a way in our justice system to know within a year if you can be paid back? No more endless litigation, only to learn after many years, sometimes even decades, that you won't get paid anyway. With what we are about to show you, you will know within a year. Interested? Then let's dive into it. This is Prime Movers, a legal podcast that covers the latest and relevant trends and insights on Philippine legal issues and topics, expertly discussed and simplified by the experienced legal team at Gorriceta, Africa, Cauton, and Saavedra. Attorney Mark Anthony De Leon, Counsel at Gorriceta, Africa, Cauton, and Saavedra will be providing an overview of the Republic Act No. 10142 or the Financial Rehabilitation and Insolvency Act and how it can help creditors to collect on its payables.
Hello everyone and welcome to another episode of Prime Movers. My name is Shai Sison. I am a counsel at Gorriceta, Africa, Cauton, and Saavedra, and your host for today. Today I am joined by my fellow counsel at Gorriceta, Attorney Mark Anthony De Leon. His practices focuses on, among others, corporate or financial rehabilitation and insolvency, litigation, labor, and public procurement. A seasoned litigator, he has vast experience in handling creditor-initiated petitions for corporate rehabilitation of special purpose vehicles or SPVs, debtor-initiated petitions for corporate rehabilitation, and corporate debt restructuring. He was previously connected with the government as Director for Procurement Management, Good Governance, and Government-Owned and Controlled Corporations or GOCC, and concurrent head of the Bids and Awards Committee Secretariat of the Presidential Communications Operations Office. Welcome to Prime Movers, Attorney Mark.
Thank you for having me today, Shai.
So, today's episode is focused on how financial rehabilitation and insolvency can be a tool, especially for creditors collecting from insolvent debtors. But before we get into that discussion, can you tell us why we actually even need this? I mean, we're already suing people left and right for, folks who owe us money. So, why add another layer by looking into financial rehabilitation?
Well, yes, Shai, you are correct that we can already sue the people that owe us money. We call that a collection case, but that method leaves a lot to be desired.
What do you mean for that? A lot to be desired. What's the reason for that?
Well, I have here three primary reasons for you. The first reason is the duration of the collection case is indefinite. Second, the decision in the collection case may have no teeth. And finally, there's such a thing called as a preference of creditors.
Wow, 3 reasons. That seems a lot to digest. Can we go through that one by one, Mark?
Sure, Shai. Let's start with the first of these reasons, which is the indefiniteness in the collection. You never really know when litigation will end. You're already lucky if you can get a court decision in the Philippines in less than 2 years, but that can still be reversed on appeal, and that can take you another 2 years. So if you are lucky, you can get a decision in 4 years, but that's if you're lucky. Sometimes it can get dragged out by another layer of appeal. So you still have to, and after that, you still have to execute whatever decision that you get, which will then take months or even years. Under financial rehabilitation, however, you will know within a year after you file the case whether you will get paid. It may take a few more years after that for you to actually get paid, but at least the uncertainty of being paid has already been removed within the first year.
Okay, so let's say after years and years in court, I finally have a favorable decision with me. What exactly do you mean by the decision in a collection case may have no teeth? So does that mean what I pretty much have is a useless piece of paper?
Not every case, though. In collection cases, getting a final court decision can take more than 4 years if you are lucky. But then again, it's challenging to enforce it because executing that court decision is a whole different ballgame. Remember, the whoever is the defendant in that collection case has had years waiting for that decision. So he has had years to plot and strategize what to do. So um, in the meantime, while after you file the case and until the execution of a court decision, they could have already dissipated their assets, for instance, or they could have already transferred their assets to other people, their relatives or even friends, to make it appear that they no longer own those assets. So by the time those 4 years are up, if you are lucky, you get trying to execute decision. The creditor is the debtor. I mean, is now an empty shell. He has nothing, no assets in its name. That is assuming that they have assets in the first place. Now, sometimes also the simple fact of the matter is the debtor might not have any assets to pay you with in the first place. In which case, then you'll never know until the end if he has assets. Of course, he will claim that he has no assets during the case, but of course, you can't believe him if you're the creditor. So, in the end, after you litigate for years and finally you get to decision stage, and that's the only time you find out that he really doesn't have any assets at all to pay you back. So in that sense, the decision that you get, it's a toothless tiger basically. So in rehabilitation cases, this is not much of a problem since asset disposal is restricted from the start. The court freezes the debtor's assets, ensuring that they remain available to pay off the creditors. This solves the problem of paper judgment in collection cases. By the time the court orders the payment of the creditors, the assets of the debtor at the beginning of the case should still be there to serve the claims of creditors.
It's funny how you qualify all your statements by if you're lucky. So, in relation to that, what do you mean by preference of creditors?
Sure. In collection cases, it is usually a one-on-one battle per case where one creditor sues one debtor to collect on the debt. In reality, however, one debtor may owe money to many people. If you are a creditor who filed a collection case, there is practically nothing to stop the debtor from paying his other creditors during the pendency of the case. Maybe some of those creditors are his relatives or even his friends. Naturally, he'd pay them off first. In short, he prefers some credits over others. So now, if you are not one of those that he prefers, well, this is the reverse. Bad luck. You will have to finish litigating your case before you can collect. Now, the problem is, by the time you are done litigating and finally obtain that judgment, the debtor, has had at least 4 years to pay his preferred creditors. Now, ask yourself, what is the likelihood that after 4 years, there's still something left for him to pay you? To mitigate this issue, attachment is the first remedy that comes to mind for us litigators. For the layman out there, attachment means that even before the case is finished, the court has already, quote unquote, reserved a portion of the properties of the debtor to answer for his debt to the suing creditor, in case the creditor wins. But in practice, it is very hard to get an order of attachment. But when it comes to financial rehabilitation, however, there is a solution. Near the beginning of the case, the court already issues a stay order. This stay order prevents the debtor from dissipating or disposing his assets. In short, the debtor cannot pay or prefer one creditor over another. So he cannot even sell or otherwise dispose of his assets. All creditors will have to wait until the court decides how they will get paid and how much. In effect, the debtor's assets are frozen while the case is pending.
Okay, how about the portion of the debt that each creditor will receive? How do we determine who gets paid how much?
Well, Shai, that's a good question. So, of course, the fact that a petition for rehabilitation has been filed means the creditor, if it's the creditor initiated, then the creditors already accept the fact that they're not going to get everything, every single centavo of their credit. But they will still get a portion of those credits. Now, they will be paid in proportion to the amount of their credit or claim. So, the bigger credit will get a proportionately bigger payment, and conversely a smaller credit will get a proportionally smaller credit. So of course they will use ratios to determine how much each creditor will get. But we must note that the important thing here is if one creditor gets paid, every creditor gets paid.
That sounds interesting and actually good to know. So tell us, if I was one of them, not so smart ones and loaned out ₱1,000,000, let's say. How can I use financial rehabilitation to collect on this 1 million from a debtor?
To answer your question, we should understand the history of financial rehabilitation. When the debtor struggles to repay his debts, it's not always due to unwillingness, but often due to temporary setbacks. If given more time, the debtor might find a way to settle his debts, but creditors are generally unwilling to extend the time within which to repay the debts. So this unwillingness makes the situation even more difficult. So naturally, it is each creditor for himself. Each creditor would want to get paid ahead of everybody else. This would result in a frenzy among the creditors who would now be swarming and pressuring the debtor to pay them first. So to ease the pressure, the debtor would likely pay off the one who exerts the most pressure. This would then encourage the creditors to exert even more pressure in the hopes of getting paid ahead of the other creditors. So you can imagine that would be a very chaotic situation. Now, financial rehabilitation was conceived to put some order into this. The idea is to give the debtor a lifeline or some breathing room. During this period, all creditors are obligated to file their claims in the rehabilitation court. Now, while the court is considering these claims and how to pay them off, no creditor is supposed to be filing cases against the debtor to collect. The court is then supposed to approve, then implement a plan on how to pay off the creditors, and at the same time make the debtor financially viable again after all is said and done. Now, financial rehabilitation was initially thought of to benefit the debtor with the aim to pay his creditors, of course, at a cost. Now, it may be different from the terms of their original agreement. It may be for a smaller amount, or what we call a haircut, wherein all creditors lose a portion of their claim proportionately. Now, or maybe can also be for a longer period of time, or sometimes even both. So now you can see that if a debtor can initiate a process by which he would pay his creditors in the end, you got to think, why can't a creditor be the one to initiate the same if all he wants is to get paid in the end? So, and that's how creditor-initiated petitions for financial rehabilitation came about. Instead of a debtor, it would be a creditor who initiates the petition. The creditor would essentially be conceding that he won't be paid under the original terms of his agreement, but nonetheless, it still beats not being paid at all.
Okay, theoretically it makes sense. It kind of sounds like it makes sense, but let's put this in actual context, in practice. Let's say I'm owed a sum of money. How do I actually go about collecting this using financial rehabilitation?
So first, you have to figure out first if you qualify under the rules. Now, generally, just because you're owed some money, that by itself doesn't qualify you. You have to be owed at least ₱1,000,000. So now, once that is established, you can file a petition for financial rehabilitation, basically telling the court that A, as far as you know, this is the total of what the debtor owes all his creditors. B, as far as you know, this is the total of what the debtor has, in other words, his total assets. And C, his total assets are not enough to pay off what he owes right now. But you as a creditor, you have a plan. You foresee that with this plan, the debtor can pay it off over time. This is called the financial rehabilitation plan.
Okay, and then after that, after filing the petition, what happens next?
So after the court receives the petition, the court will then assess the sufficiency of the petition in form and substance. Basically, this means that the court is assuming that whatever you said in the petition is true. Then will rehabilitation of the debtor be in order? And if the answer is yes, then the court will issue a commencement order. This basically starts the proceedings. Now, the commencement order would also include what we call a stay order. This is the important part because with that stay order, it halts all debt collection efforts by all creditors against the debtor. And it requires all the creditors to submit their claims to the rehabilitation court for consideration and resolution. So the court also appoints a rehabilitation receiver who will then assess the debtor and determine the possibility of rehabilitation and how to achieve it. If the court agrees with the rehabilitation receiver's assessment, it approves the rehabilitation plan that the receiver will also suggest and implement the rehabilitation plan. So finally, this rehabilitation plan to be proposed by the receiver should also include how the creditors are paid. After the approval and implementation of the plan, all creditors are considered paid, and the debtor would then exit the rehabilitation proceedings debt-free, essentially giving it a new lease on life.
Okay, you also mentioned that there's a possibility that a creditor would be paid less than what he's actually owed and for a longer period of time than what you guys originally agreed on. So, why then would you resort to this if it means getting paid less plus for a longer period of time?
That's a good question, Shai. So it's not, in this case, it's not even a possibility, it's a certainty that if we do this rehabilitation, they will definitely get less, and most likely they will definitely be paid for a longer period of time. But remember, the reason why it came to this point is these creditors are not being paid at all. So that is the situation they're foreseeing. So they, if they are being paid in full and on time, there's really no reason to do this. But this is for those creditors who are not being paid at all, and now they're being threatened by not being paid anything forever. So faced with that possibility, then this rehabilitation proceedings may be for them, wherein they can file this petition and get a chance at getting paid, if not not in full and not for the original period, but at least they can get something back in return over a longer period of time. For instance, think about it, if the debtor is awash in cash or has the ability to pay but simply does not want to pay for whatever reason, then this proceedings is not for you, the creditor, since the element of insolvency is not present. Now, the financial rehabilitation is primarily designed for creditors who realize that they might not get paid in full. For instance, the debtor has limited assets, so it chooses to pay other creditors first, or maybe the debtor may also have a viable business, but it does not have enough income or cash flow to be able to pay its debts on time. So at the rate things are going, you as a creditor can be that one creditor who thinks clearly and decides that if we don't give the debtor some breathing room, all of us creditors will lose out, or at least lose a lot more than we should. If we can give the debtor some breathing room, he may actually pay us back more, if not all. If we shut him down now, we would lose a lot more. So if you are the creditor who sees that, then financial rehabilitation may be for you. Give our firm a call. Let's talk.
Okay, so, I guess it's a case of it's better to get a bit of something than nothing at all. But, Mark, what caught my attention, and probably the attention of most of our listeners, is that you said it will only take a year. Did I hear that right? I mean, how is that even possible in the Philippines for just 1 year?
Yes. Yes, you heard me right. It will take a year, but I have to clarify what will happen within that year. Under the law, the court has only 1 year to approve a rehabilitation plan. So this means within 1 year from filing the petition with the court, the creditor will already know whether they will get paid and how much and for how long. So that gives the creditors certainty within that 1 year. Now, I want to clarify that this does not mean that the creditor will be paid within that year. This payment period can be extended beyond that 1 year, depending on the length of the rehabilitation plan approved by the court, or perhaps even if there's some agreement between the creditors. Now, nonetheless, this rehabilitation proceedings, even if the creditor is not paid within that first year, it still delivers some sense of certainty as to payment. This beats collection cases where the court is under no deadline to decide the case and where the creditor can be in limbo for years, sometimes even decades. But of course, this is what is in the law. Of course, we have to, when we file these cases, as a creditor, you have to be vigilant to make sure that the court itself also follows the law to approve a rehabilitation plan within that first year.
Mark, a lot of folks often feel that they're at the mercy of our snail-paced judicial process. And it's very good to know that we actually have alternatives at our disposal. Thank you, Mark, for breaking down this complex topic into very digestible pieces for our listeners and myself, actually.
You're welcome, Shai. Financial rehabilitation provides a structured framework for both debtors and creditors during financial distress, and understanding it can be a crucial tool in navigating these challenging times. But we hope that this podcast episode was able to help our listeners understand it better.
And that's a wrap for this episode of Prime Movers. We hope you enjoyed and learned from our discussion. Tune in for more episodes of Prime Movers. Once again, this is Attorney Shai. Thank you for listening.
Prime Movers is produced by Gorriceta, Africa, Cauton, and Saavedra. Gorriceta is a top-tier full-service firm under the Legal 500 and Chambers and Partners. Visit our website, LinkedIn, and Facebook pages for daily legal developments.